All right. Welcome to the 33rd meeting of the Fair Employment and Housing Council. The meeting has been called to order, and to get us started, DFEH Legislative and Regulatory Counsel Brian Sperber will perform the roll call.
Chair Mandelbaum.
Present.
Councilmember Brodsky.
Present.
Councilmember Iglesias.
Present.
Councilmember Ortiz.
Present.
Councilmember Sandoval. Councilmember Asher.
Present.
Director Kish.
Well, thank you all for attending, both in person and from afar online. We are happy to be back at the state capitol, and our meeting is being webcast live, and the video of the meeting will also be available afterwards on the website and YouTube channel of the department. If you're following along on the webcast and you want to participate as the agenda unfolds, you can do so by emailing the council at fehcouncil@dfeh.ca.gov. As an initial matter, we want to acknowledge Mr. Sperber and Tatiana Grant from Business Services, who are here from the department. And if we can, as is our custom, just kind of go around the room and introduce ourselves on a voluntary basis so we know who we'll be spending the morning with. We can start with you, Tom.
My name is Thomas Coleman, and I'm the legal director of Spectrum Institute, which advocates for people with disabilities, especially in conservatorship proceedings.
Beverly Bueno, Equal Employment Opportunity Officer for the California Air Resources Board.
Hi, I'm Pamela Cohen, Disability Rights California Attorney in the Sacramento office.
Hi, I'm Desiree Lamar, Equal Employment Opportunity Officer for Board of Equalization. Good morning. I accept the voluntary option and will pass.
Sounds good. Well, thank you all for attending, and we look forward to your participation as the agenda unfolds. If you haven't already, there are materials for today are here at the front of the room by the door, and if you're following along online, you can find the materials for today's meeting at the same website page that the live stream is on. Highlights of today's meeting will be a public hearing on the employment regulations regarding the use of criminal history, the Family Rights Act, and the New Parent Leave Act. We will also review and consider a post-comment draft of the employment regulations regarding religious creed and age discrimination, and review and consider a new draft of regulations regarding harassment and prevention training. And as always, there'll be opportunities to comment from the public as we tackle each agenda item. The first order of business is to approve our minutes from our last meeting, which is attachment A to the meeting materials.
So moved.
Second.
All right, well, we're flying by. I like it. No recap required. Any public comment specifically related to our agenda, or the minutes, rather, from our last meeting? Hearing none. All those in favor say aye.
Aye.
Any nays? Any abstentions? All right, the minutes are adopted. The next order of business is council member reports, and I'll just kind of start by informing people, if they're not already aware, that if you thought you heard an extra name on the roll call, you are correct. On September 6th, that's the wrong one, but Governor Newsom has appointed a sixth member of the Fair Employment and Housing Council on September 25th, Gabriel Sandoval, who will be with us at our next meeting. He brings a wealth of experience, both in terms of civil rights and education issues, and will be a great addition to the council. So he'll be joining us for our next meeting, which will be in the coming months and posted soon. With that update, I'll turn it over for additional council member updates. And I'm looking at you guys because there's a very exciting one, highly relevant to you.
I think the regs.
Oh.
Yes. We are very pleased to inform people who may not have seen it posted that the Office of Administrative Law has approved has finally, after many years, we have approval of the housing regulations, the first set of housing regulations ever in California under FEHA, and they will be effective on January 1st of 2020, in just a few months, and they are they cover a number of very important topics, including discriminatory impact and harassment, retaliation, reasonable accommodations, use of criminal history and a couple of other topics as well. And so we're very, very pleased that those regulations are effective now. So that is our biggest news. Will be effective January 1st, sorry, yes. But are final now and are approved, so.
Well, it's a big lift and a great work by the two of you and the council and everyone who participated in public. As you mentioned, the fair housing law in California dates back to the 1963 passage of the Rumford Fair Housing Act, and there's never been regulations implementing it, so this will be a big help.
Yes, and I look forward to being able to report in future months. I'm getting lots of requests already to make presentations on the regulations, so I will keep people posted on that.
I have two small things. One is I, along with about 153 other law professors, signed on to a comment letter to HUD with regard to a proposed revision of its disparate impact regulation. And also, just if there's any attorneys who are young attorneys interested, the San Francisco office of HUD is going to be hiring some entry-level fair housing attorneys in the next couple of months. So if anybody is interested, they're looking for folks, and I'm happy to kind of steer people in the right direction if they're interested.
Any other council member reports? None. All right. Well, we'll move on from a report from the department. Director Kish could not attend today's meeting, but we do have Mr. Sperber, who is going to give us a legislative update on what was a very busy end to the legislative season for our areas.
So Director Kish sends his regards, and he wanted me to mention 3 bills. On the legislative summary section of our website, we'll have a whole rundown of all the bills, but the 3 that he wanted me to mention are AB 9, that extends the filing deadline for employment complaints only from 1 to 3 years. SB 329 redefines source of income for the purposes of the FEHA. That's a protected basis in housing only. So the current definition of source of income does not include government housing subsidies paid to a housing owner or landlord on behalf of a tenant. This is most often Section 8, but we're talking about all these programs. This bill removes the exception that allows landlords to turn away tenants who hold government housing vouchers. And in practice, the bill requires landlords to accept otherwise qualified applicants who don't use such who use such vouchers to pay, and allows people to file complaints with the department. And the last one is SB 222. It expands the FEHA by adding veteran or military status to the bases upon which housing discrimination is prohibited. That's already an employment category, so this makes veteran or military status part of housing as well. It also explicitly adds VASH grants, Veterans Affairs Supportive Housing, to the definition of source of income, but the previous bill, SB 329, would include that as well.
Great, thank you. Well, we'll have to have an eye towards implementing these to the extent they need either changes without regulatory effect that just incorporate the statute or clarifications of those statutes.
Yes, several of these obviously impact housing, if not all of the second 2. And I must say the Section 8 protection is long overdue. People in the community have been seeking that change for decades. So we're very pleased that that bill was enacted, and we're looking forward to incorporating it into the regulations in FEHA.
Great. Well, we are at our public hearing, so we're going to go on the record and start our public hearing. So we are now on the record, and it is Wednesday, October 23rd, and we're here at the State Capitol in Sacramento. My name is Chaya Mandelbaum, chairperson of the Fair Employment and Housing Council, and joining me today are members of the council, council members Dale Brodsky, Dara Scher, Tim Iglesias, and Joseph Ortiz. Even though we've had an informal introduction off the record, let me again welcome you to this hearing portion of the meeting. The purpose of this hearing is to receive public comment regarding issuance of amendments to the FEHA's employment regulations that relate to new legal provisions regarding criminal history in employment and parental leave. This rulemaking clarifies, makes specific, and supplements existing state regulations interpreting the FEHA that are set forth in Government Code 12900 et sec. The proposed regulations are slated to appear in the California Code of Regulations, Title II, Sections 11017.1 and 11087 through 96. Copies of the proposed amendments to the regulations are available at the front of the room and are reflected in Attachment D to today's materials, and the notice and initial statement of reasons are reflected in Attachments B and C, respectively. The text of the Council's regulations is also available on the Council's webpage. We're holding this meeting as part of our formal rulemaking process, and it was noticed in the California Regulatory Notice Register published on September 6, 2019, and also via email sent to more than 7,500 individuals and stakeholders, and through the Council's webpage. Pursuant to the notice, we're taking testimony today on the proposed amendments, and we'll also accept written testimony, or written comments rather, on the regulations until 5 o'clock today, October 23rd. So if you haven't already submitted them, you can submit your written comments to the Council at fehcouncil@dfeh.ca.gov, or you can mail them instead to the Council, care of Brian Sperber, the DFEH's Los Angeles office, located at 320 West 4th Street, 10th floor in LA, 90013. You can also give your written comments if you brought them today to Brian. And if you didn't bring a written comment to provide to Brian today, make sure you get it in by 5 o'clock this afternoon. Anyone who testifies here today will, or submits any written comments, will receive a copy of any changes or amendments the Council makes to the proposed regulations, and will also have an opportunity to submit comments if during a 15-day period if the Council makes any substantive or substantial change to the proposed amendments after receiving the public comment. And also anyone who requests a copy and an opportunity will have that as well. So we'll consider all of the comments made here today, as well as all comments received in writing, and we'll respond to those comments in our final statement of reasons, which will be part of the rulemaking record. So, as you can tell, this hearing is being transcribed by a court reporter, and the transcript of the hearing, as well as all written comments received, will also be part of the official rulemaking record. Because this hearing is being transcribed, as you'll notice, I am speaking a little bit slower than I would in the everyday course of conversation, and we would appreciate if you would do the same so that our court reporter is able to take down your testimony. You won't be sworn in when you testify, but we do ask that you come to the front of the room and speak into the microphone so the court reporter can take down your remarks. Please start by stating and spelling your name and any affiliation that you are offering your remarks on behalf of. Also, if you're commenting on a specific regulation, it's helpful if you can identify the section and subsection of the regulation so that we can refer to it as you're providing your comments. So we'll hear testimony until all those wishing to testify today have had an opportunity to do so. Any initial questions? Seeing and hearing none, we're ready to begin. So if anyone would like to provide public comment on Attachment D, the proposed regulations, now would be a good time to come to the front. Brian, any email comments?
The internet's down.
Oh, okay. Well, why don't you kick us off since you
All right, I
have
have
some.
some comments.
Yeah, I'll check.
I'm Dale Brodsky. As you know, I am a member of the council, but I'm making these comments not wearing that hat. I'm making these comments as a member of the public. I'm an attorney in practice. I have been working in the field of employment law for more than 40 years and have been immersed in the statutes that we're addressing here for all of that time, most of that time. So I do have a couple comments. I think that the regulations look really good. I just want to focus on two things. The first is a minor one with respect to the regulations on criminal history. When I looked at the definitions and read, I think that there should be a definition of conditional offer of employment in 11017.1 B4. There are a bunch of definitions, and then I'm going to submit something in writing in which I have a simple proposal for how to define that. It's because conditional offer employment is so important in these regulations in terms of when an employer can request information and when they can't. And I thought it would be very helpful to have a definition on that. Do you want me to read my suggestion, or do you want to just take it by written?
Well, if you're gonna have it in writing, we'll see it there,
Okay.
but whatever you
Okay.
prefer.
Then the second and only other suggestion I have is with respect to the Family Rights Act and PLA one, and this is specifically about 11087D1 at page 7, the definition of directly employs. And I would ask the council to consider changing this definition to update it to make it consistent with the definition of employer in 11008 subsection D. As it's written now, the definition that's provided under the proposed regulations is directly employs means the employer maintains an aggregate of at least 20 in parens NPLA or 50 in parens CFRA part or full-time employees on its payroll in parens S for each working day during each of 20 or more calendar work weeks in the current or preceding calendar year. I want to focus on that language. In looking at it, I reviewed the legislative history from CIFRA, which I've given Brian a copy of, from when it was first enacted in 1991. I wanted to see whether there was any definition or any reason why that language had to be there. There's not. I looked at all case law that I could find on this subject, and I could not find any case law that justified having that definition. So with that background, what I then did was, I think there are 4 reasons why that language should be changed and made consistent with 11008D1, which are the definitional, in our general FEHA employment regulations, we've defined what it means to be an employer. And in that context, we took out language that was the language that's still in this one that would have conditioned employers, it would said that employees had to be employed during 20 weeks during the previous calendar or during the calendar year. And we took that out and replaced it with a different manner of counting. That was why the original language, what the original language in our Family Rights Act regulations that I worked on a long time ago mirrored the language that had previously existed as the definition of employer. We changed that back in January, at our January 28th, 2019 meeting. We voted unanimously to approve amendments to the employment regulations, which changed that language, took that out, and provided a different definition of regularly employing. Nevertheless, as it's currently drafted, these CIFRA regulations still use that old wording. So really, I think we need to change it first because the counting mechanism that is still there, the 50, relying on 20 working weeks during the calendar year, is not based on any California statute. It is similar to, it is the same as FMLA in Title VII, but it's not any California statute. Secondly, now, I mean, before the two definitions were mutually, they were consistent. The definition of employer, directly employing and regularly employment for FEHC purposes were consistent. Now there's no regulatory source for the way that it's still written. Third reason is that in and of itself, 11008D2 expressly states that for the purposes of CFRA and MPLA, employees must be counted in the same way as they're described in 11008D1. So we've actually said that ourselves, that that definition applies. So you can't, I mean, it doesn't make sense to have another regulation that's inconsistent with that. And fourth, the definition of employer for Pregnancy Disability Leave Act does not require an employee to have worked, you know, you don't have to have had 20 or 50 employees on the books for 20 weeks. So now you've got PDL, pregnancy disability leave, which often runs sequentially or, you know, with CFRA, which as it's written now would be subject to two different counting mechanisms, which doesn't make sense. So for all those reasons, I really urge us to change that language. I've proposed a very simple fix in my written letter, and so and then there's one other suggestion that I had, that I think that the existing language has it says that it's people on the payroll. I'm suggesting that we omit payroll, because what the statute says is there have to be employees who will receive a wages or salary. That's much more explicit than being on the payroll, because somebody could be an employee and not being on the payroll, or someone who's not an employee could be on a payroll. So you want to, and that's, in my letter, I have a citation to some dicta in a Supreme Court decision in which Justice Scalia made in a different, slightly different context, but observed that as well. So I would suggest just going back and using the same wording, wages and or salary, and that's also incorporated in my written comment. So thank you.
Thank you, Mrs. Brodsky. Not Councilmember Brodsky. Any other, no, okay, so we don't have any email comments. Anyone else wanting to provide public comment on the proposed regulations regarding criminal history of the California Family Rights Act and the new Parent Leave Act?
I've forgotten, is it appropriate for council members in this hearing to make comments or not?
I think it would be the next one, because this is the draft we already voted on, and then we'll amend it once we process the written public comment and Mrs. Brodsky's oral public comment and written comment. Seeing no other people who are wishing to provide public comment, we will conclude with our public hearing portion of the meeting. So thanks to those who plan to submit written comments. We look forward to reading it, and please remember to get it in by 5 o'clock today. So with that, the hearing portion of this meeting is adjourned. And we are now off of the record and picking up with our regular meeting agenda, and our next order of business is an update from the Government Code Section 11135 Subcommittee. So I'll turn it over to council members Brodsky and Schur.
Well, we don't have a lot to report. We finished, Council Member Schur and I finished our portions of drafting the initial statement of reasons. They are currently being reviewed and will be submitted to the Office of Administrative Law, after which they will come back to us either with questions or need to do further revisions, or back to the council and then open for public comment. Unless Mr. Sperber has any further update on that, I think that's what we know at this point.
Just one small clarification. So internally, we're reviewing it. We need our agency, Business Consumer Services and Housing, to sign off on the fiscal impact, which is 0. After that, it goes to the Office of Administrative Law. They don't give substantive feedback at this moment, so it's just a notice for a 45-day comment hearing like we just had. That should, unless we have a meeting in 2019, that should be at the next meeting.
Okay, so you think that that will happen at the next meeting?
Yes.
Okay.
Yes, so we're looking forward to being able to begin the official rulemaking process at the next meeting on those proposed regulations, which, for those of you who are not familiar with them, that the regs implementing that statute have been on the books for decades, and there were major statutory changes to the framework of the law, and they were transferred to the Department for Rulemaking, so it'll be the first major revision of those regulations in many, many, many years, and they're quite comprehensive. So we're looking forward. The scope of them required a lengthy process, but we're looking forward to initiating the formal rulemaking on them at the next meeting.
Great. Any public comment on the 11135 subcommittee item? Mr. Coleman.
Good morning. My name is Thomas F. Coleman, and I'm legal director of a nonprofit, Spectrum Institute. And we do a lot of research, writing, and advocacy, particularly focused on reforms to conservatorship systems and guardianship systems, conservatorship in California and guardianship systems around the nation in all of the 50 states. And our work focuses on federal, state, and local government agencies in all three branches of government whose jurisdiction touches upon this area and who have some type of authority to weigh in or create some reform. And I'm glad that I finally found you and realized that you do have some jurisdiction to take action in this area. I submitted a written proposal for you to consider, and I just want to touch on that a little bit now in the little limited time that I have today, although I'm sure I'll be coming back, for the public comment section in the future as regulations are being reviewed. Right now, there are probably, nobody knows for sure because nobody keeps track of how many people are in conservatorships, probate conservatorships. It's hard to believe. The judiciary is charged with protecting these individuals, but the judiciary doesn't know how many people they're protecting. So that tells you something right there about the dysfunction of the conservatorship system. But I'm estimating there are about 60,000, at least 43,000 adults with developmental disabilities, and the rest seniors and others with cognitive disabilities that stem from illnesses or injuries. There are about 5,000 new cases that are initiated each year in California. And in this system, which of course is operated by the superior courts, virtually every single individual has serious disabilities, which means the Americans with Disabilities Act should apply to each and every one of those individuals to ensure that the public entity, which of course has obligations under Section 11135, and that includes the courts, since they receive state funds, they're a public entity, they have duties to enforce 11135 and also the Title II of the ADA. And to ensure that each and every one of these individuals has effective communication in the proceedings and meaningful participation in the proceedings. And I've been studying this, started out by accident and then another accident, and then finally I started delving into it to see whether these were isolated incidents that I was observing or whether there was something, a pattern in practice, and whether there were policy problems. And I found that the problems are systemic. And what I found is that the courts are not obeying the ADA. They're not applying it to individuals. There's no individual assessment of the people to see what accommodations they might need. And the court rule, I just spoke last month to the Judicial Council to thank them for approving some new training requirements for court-appointed attorneys, but also to point out to them that Rule 1.100, I believe it is, which is the ADA rule for the courts, is premised on the requirement that people make a request. And they actually have literature that says no request equals no accommodation. Well, that is in violation of federal law. Federal law requires accommodations when a public entity gains knowledge that a person has a disability that interferes with their participation in the service being provided. A request is one way that an entity gains knowledge, but not the only way. In conservatorship proceedings, the judges know right as soon as the petition is filed, there's a verified petition saying this person's disabilities are so severe that we should take away all or most of their rights because they don't understand what's going on and they can't control their life and blah, blah, blah. So there should be some type of application of the ADA to each and every case as a matter of routine, but it's not happening. In Sacramento and some other counties, the judges in many cases do not even appoint an attorney. So can you imagine a person with serious cognitive disabilities being expected to represent themselves in these proceedings where their rights are being taken away? It's preposterous, but that's what's happening. I filed a complaint with them on behalf of Spectrum Institute, on behalf of the class of people, because the individuals, because of the nature of the disabilities, can't complain, can't appeal, don't appeal, so these problems are never corrected by the normal appellate process of the courts of appeal and Supreme Court. In the limited conservatorship system, which is designed specifically for people with developmental disabilities, in the past, since it was created in 1980, I've identified one appeal by a limited conservatee, and that's before the Supreme Court right now, and that took a lot of doing to make that happen. And so these are not being corrected in the normal appellate process. So the judges, the superior courts, are not accountable. And you know, in human nature and everything else, no accountability means you've got a real problem on your hand if there's a lot of people, especially people who can't complain. Therefore, the jurisdiction of the Department of Fair Employment and Housing to enforce 11135 in the context of courts systematically violating the rights of people with developmental disabilities or seniors with cognitive challenges is critical. And it's also critical that the director consider using the director's jurisdiction to open a director's investigation. I filed a complaint, or actually an inquiry, with DFEH about the Sacramento situation when Sacramento court said, thanks for alerting us, but we choose to do nothing to make any changes. So I asked the DFEH to open an investigation. Again, these individuals don't even know that their rights were violated and don't have, the ones that didn't have an attorney, so they're not about to file complaints with DFEH. So I thought the next best thing is some type of third-party standing by an advocacy group on their behalf, or the director just, it'd be the same thing as I suppose if the director saw or a police officer sees a crime committed or no, and so on, do you really have to have the victim who's in a coma file a formal complaint? The victim cannot file a complaint, but if it's a matter of written record, a policy that's right there in plain sight, you have a violation that is obvious. And especially if there's a pattern in practice, as I showed with my research, case numbers and so on, that these people never got an attorney. But that's just the tip of the iceberg. I won't get into all of the ADA violations, but the Judicial Council's own rule, which I brought to their attention, I assume that something will be done, hopefully, by them, and I sent a letter to all 58 superior courts, since they're all autonomous, saying, you've been relying on the Judicial Council rules and educational materials, and I even researched the training materials for the judges and discovered the same flaw is in there. Everything's premised on a request. So this gets to the need for regulations that you're already working on. And from what I've seen so far, the only mention of people with cognitive disabilities is just the word mental in physical and mental disabilities. And I've noticed in some other areas that you actually specify the types of scenarios that would be a violation. And also later today, when you get into the reasonable accommodation and housing regulations, no substantive change, but I looked there and saw all these scenarios that are like guidance for people that if such and such happened, you know, then this would be a violation or whatever. So I'm encouraging you to use your rulemaking authority to make sure that there are rules that apply to the courts, that there are scenarios for the rights of people with disabilities in conservatorship proceedings, giving specific examples, maybe specifying that it's an unlawful practice not to provide an accommodation, such as an attorney for someone who cannot conceivably represent themselves effectively in such a proceeding. I know it's a big ask because you would be taking on the judicial branch that has been negligent, basically willfully indifferent, because they've been approached over and over and over again for the past several years, and the changes have been minuscule, if anything. So the rulemaking authority is one area, and the other is, you know, I know you have limited staff, you have limited time, you're all volunteers, although you do have some staff, but still it's limited, and your agenda is so huge as to what the territory that you cover with your jurisdiction, but you have the authority to create an advisory group. So create an advisory group on the ADA and conservatorship proceedings, and bring some experts in to work together to develop some proposals for you. Also, you have the authority to hold hearings, and even the subcommittee. Hold a hearing in Oakland and one in Los Angeles, where the areas where we have the most people that are actively involved in conservatorship reform. Alameda County is terrible, but there's so many people that are coming forward, and Supervisor Nate Miley is trying to lend his support to it. So hold some public hearings and gather evidence that way, and then ultimately issue some type of a report and findings about this area. And I've searched high and low. I've approached every public official that I could think of in all three branches of government, state and local, even federal. Everybody passes the buck. Nobody has jurisdiction. Nobody has the funding. Nobody wants to do it. And so here I am on behalf of a group of individuals who are not able to be here themselves, are not organized as a political force, asking you to do something. And I'll just close by saying that, you know, I started coming to your predecessor commission back in the 1970s when we were talking about sexual orientation discrimination in housing and employment, and pushing for regulatory, you know, for the regulators to kind of go ahead of or be generous in your interpretation of existing law, sex discrimination. I see that's now before the Supreme Court of the United States. Well, that ask was made of your predecessor in the 1970s. It didn't happen, but eventually we got statutory. And for as far as housing goes, the DFEH refused to use its UNRAC jurisdiction to protect, at that time called homosexual discrimination against homosexuals in housing. And it took some real, let's say, arm twisting and intervention to get the department to change its mind. And then it said, oh, okay, we will accept housing discrimination cases. And that started happening. So, you know, you can provide leadership in this area. It's desperately needed. And I know you can't do you could do all of the requests, but it would take staffing and funding and all of that. But to do something, such as an advisory committee or some of the other suggestions that I've made, and see if you can use your leadership and your position of authority to help a group of people who this will go on forever unless there's some type of intervention, and you could be the ones that, you know, kind of turn the tide.
Thank you. I know, I had a couple questions, and others may as well. So just process-wise on the regs, so there's been a draft of the regs, which you see in 1135. Those have already been voted on. Those will go into the public comment, and then from there, they'll be issued for 45 days. So that would be a good time to get like substantive written comments about, additions, one of which you foreshadowed. I think what would be helpful on that front to me is a deeper dive. Obviously, what you submitted to so far was highlights of various areas. But as someone who doesn't specialize in that area, I think the parts that would be helpful to know are what written things, and you mentioned one from I think it was through the Judicial Council, but what is it? What published items are out there indicating that the judiciary is interpreting the obligation to provide a reasonable accommodation in the narrow fashion you suggested?
Yeah.
What in the ADA says otherwise? Darren may
Correct.
know that off the top of our head. I don't. And then what kind of accommodations we're looking for? Because obviously the conservatorship program in general is an attempt, albeit imperfect, to address that disconnect of people who can't make decisions on their own. So you mentioned one is having counsel, obviously.
Correct.
What are other common accommodations that I recognize sometimes you're saying are not being, there is no accommodation, consideration, or interactive process, period, because they're not making it, and even if the disability is obvious, it's not happening.
I'll definitely submit what you're asking for.
But basically, what are those accommodations that could be provided that are reasonable
Well, of course,
accommodations?
for each individual, it's going to be the individual assessment. So you have an ADA coordinator in each court, and they are great at doing things with respect to mobility disabilities, or people who are deaf or hard of hearing, who have other things that are like easily remedied. And people with cognitive disabilities is, the most difficult challenge of all. And so they don't do anything at all. And so, an individual assessment of what would it take to give them maximum participation in this proceeding. Because as you say, the proceeding is attempting to address the disability, but it's addressing it in a way where the individual is considered a piece of furniture rather than a participant in the proceedings. And so I will get to you what those types of accommodations, what the assessment process would look like, and what types of accommodations should be applied. Like, how about making sure they're present in court? Or if for some reason they can't be present, having a video situation where they can see it on Skype or some other thing where they're at, so they can see what people are saying about them and about their life. But a lot of people can make it to court, but they don't even come to court, and the court doesn't require or give them an option saying, are you waiving your right? So there's a number of things. As far as the first one, like what evidence is there that the Judicial Council is not obeying the law, and what does the law say? I've already got that. So I submitted a comprehensive report to them of federal law, federal cases, and there was one particular sheet that shows, on the left-hand column, what the Judicial Council says, no request equals no accommodation. And the right-hand column has federal regulations and federal court cases that say just the opposite, that say you cannot require of someone a condition that they cannot meet. Otherwise, you will be excluding an entire class of people from accommodations because they don't make a request because they can't. And therefore, federal cases say that knowledge by the entity is the key to a sua sponte obligation to provide accommodation, or at least inquire on your own motion without request. Now, the courts are not going to like this. This is going to take work and staffing and money, but that's federal law. And that's what DFEH is here to do, because the legislature said through 11135, it should be at least as vigorous as federal law requires, if not more so. And that's what you're here to do, is to create guidance or regulations to help implement existing law. So I will give you that existing law. I'll give you the smoking gun on their website that comes right out and says no request equals no accommodation. And then I'll give you also what you're suggesting about what would appropriate sua sponte ADA assessment and offering of accommodations look like in a conservatorship proceeding. Yeah, both are excellent requests, and that, I guess, is the next step forward.
Do other states have accommodations rules for conservatorships?
No. We're always, not always, but California often is on the cutting edge. Although I must say the Office of Administrative Law in the state of Washington, about a year and a half or 2 years ago, adopted a comprehensive set of new rules for all administrative proceedings of any type whatsoever. As soon as a judge or administrative law judge or participant sees that somebody has cognitive and communication disabilities, that they're not able to represent themselves in the proceeding, it has to be a referral to someone to assess and determine, and appointing what they call a representative, because it doesn't have to be an attorney in an administrative proceeding, but it's the equivalent, an advocate, is the accommodation that's provided along with whatever other ones. And in the Washington rules of court, the ADA rule points out that appointment of an attorney may be the appropriate accommodation for some people. But by and large, I mean, I started out knowing nothing a few years about ADA, almost nothing about disability rights. And because this was such a huge problem that affected so many people and no one else was really looking at it, I just decided to become self-educated, and I'm now like 9,000 hours into this pro bono. But that's good, because I've looked at it from a different set of eyes, a different perspective of somebody who's questioning everything and looking for everything. And so I found almost nothing. That's why when I filed a complaint with the department on behalf of Spectrum with the U.S. Department of Justice against the L.A. Superior Court for ADA violations in its court-appointed attorney program, because the attorneys, it would be like let's say a sign language interpreter that didn't have any training and was just making it up, like some of these attorneys do, or that they were going too fast and people couldn't, understand so there have to be certain, standards and so on. So that complaint is still pending with the U.S. Department of Justice, but I realized they don't have any standards at their end as to what ADA compliant legal services would look like. So then I spent, a few hundred hours developing those standards. So we're at the beginning stages of this whole area of applying the ADA, especially in judicial proceedings, to people with cognitive and communication disabilities, including people with developmental disabilities. So almost nothing is out there. We're going to create something for others.
I wonder, I mean, look, our place is to talk about what the legal standards are, but it sounds like this is really more of a judicial resources issue, isn't it? I mean, to the extent that they're going, from the employment context, we look at undue hardship versus reasonable accommodation. Some of these things seem to be kind of ambiguous, or perhaps might be more than they have resources for. Wouldn't that be something that we need to deal with via the California legislature or the judicial branch?
Well, maybe a little bit of that, but for example, courts appoint attorneys all the time. And as a matter of fact, in conservatorship cases, most of the time. And with respect to limited conservatorships, they have to all the time. So appointing attorneys for minors, for juveniles, for criminal defendants, for conservatees, that's a normal part of the judicial function. There's no undue hardship there. And the money does not come out of their budget. So it's not a hardship on the judiciary to appoint an attorney. The money comes from if they're indigent, it comes from the county, not from the court.
Some of the things maybe have significant expense. So one thing that resonated with me when you were talking,
Yeah.
I come from very large counties where there are some rural areas, And an access to justice issue is that someone may have to drive 3 or 4 hours to get to a court to hear their matter. I think that's a problem.
Yeah.
You had mentioned video conference. I'd love to see that kind of availability, but I don't think that we can, as a rulemaking body, mandate that. I think that that's something that would have to go through judicial resources, perhaps the legislature, but perhaps an advisory committee can look at that.
Well, you know, for example, these courts in a lot of areas, they have things by phone. They have the attorneys remotely by phone. There's no hardship. So maybe you start out with phone. So the person, you know, maybe it doesn't help every single person, but it helps a lot more than right now. So I'm not saying that this is just a you know, an all or nothing and just, but I'm saying that these are things that could come out in public hearings or come out through an advisory committee where concerns like that are raised and dealt with and so on. And then you take from that and other materials that I give you addressing the concerns that you mentioned or the issues you mentioned, you do what you think you can do and then make reference that some of these other things may have to be dealt with otherwise. But the judicial branch is quite capable of asking for money when they feel they need to meet federal law. For example, when they had to start dealing with civil cases in which they had to provide language interpreters, federal law required it. There was no money in their budget, not enough money in their budget. Doesn't matter. Federal law requires it. The DOJ said, do it, or we'll sue you. And so then the judicial branch went to the legislature to get the funds to comply with the requirement under existing law. So I don't think it's so much, you know, unless it truly amounts to something that is a fundamental restructuring of their service or something, you know, then that's right in the law. Then you can't require them to do something that's obviously, you know, an undue hardship. But it's not an undue hardship for them to make a request for funds from the legislature rather than saying, because who's going to make the request? This class of individuals doesn't have the resources to go to the legislature to do that. So put the burden to the greatest extent possible without being, you know, unreasonable on the judicial branch to meet its obligations under 11135, which incorporates ADA, and then let them, you know, and let them come and make public comment about the regulations you're considering imposing. Let's see what they have to say.
Thank you for coming and for this testimony. I'm quite familiar through my many years of work at Disability Rights California with the problem. I think I don't think anyone would disagree that there are significant problems and abuses in the conservatorship system, and inadequate or lack of counsel is certainly one of them.
Yeah.
Lack of other resources. Many people in the disability community are looking hard at alternatives to formal conservatorships or making sure that conservatorships are limited as required by the statute. Some of that's routinely ignored. Certainly people coming off of holds have significant problems. I don't disagree with you that there's a very significant and widespread problem with this system, and that it's a difficult problem because it's the intersection of people who really can't care for themselves, sometimes with family members who want to overstep their bounds in making decisions for those people, sometimes people who abuse those people or take advantage of them, and other people who just get lost in the system, as well as, in some situations, the need for there to be someone assisting someone who has, you know, significant dementia, for example, aging elders. That said, the scope of what you're asking for is very broad. I think we should look at what pieces of it fall within our purview. I certainly would urge you to take a close look at the regulations when they come out under 11135. We don't directly enforce the ADA, but certainly 11135 is intended to be to provide equivalent rights. So we don't directly or indirectly enforce the ADA. We enforce 11135. We write regulations to enforce 11135, which has to be consistent with the ADA and provide as many rights. And I read your letter, and I, particularly in a couple of areas such as standing, third-party standing advocacy, I think you should look closely at the language. It may already do what you're asking us to do, and if not, we'd really appreciate specific comments on it. Also on definition of disability and communication issues, we may have already addressed these in this draft. I know that our definition of disability includes, a wide range of disabilities, mental, cognitive, it's very broadly defined. So I think it may address your concerns, but if not, we'd certainly like to hear more specifically from you about specific changes. So if you have, what's always most helpful to us with any comment is proposed alternative language with supporting authority.
Like you heard earlier, right here.
Yeah, and it really is, people say, give us a red line version, and they give us the authority to support it. That is always the most helpful as we're working through these massive sets of regulations.
I will do that.
So I would look at those things. I'd be, because I think we intended in this draft of regulations to have as broad a standing as the statute would allow, and to have as broad a definition of disability as the statute would allow. So I think those things may already be there, which are in your comment letter, consistent with statutory authority. I am interested in a case law you have that someone has an obligation to provide an accommodation in the absence of a request. Now,
Only a public entity. I'm not talking about employers and landlords.
Right. But I'm pretty clear that if you ask for something and it can be construed as an accommodation, you don't have to use the words accommodation.
Right.
And I think that's very clear.
Well,
But-
our employment regulations go beyond that, because if it's apparent, if the disability is
Is
apparent,
apparent.
then there is an affirmative duty on the part of the
Right.
employer
But-
to say,
Yes.
do you need an accommodation?
But that cases on that point, which you said you have, would
Yes.
be, I think, helpful to us in framing that language if it doesn't already exist in the draft. I think some of the other issues that you're asking for, I think we'd have to have some discussion about what the scope of our ability is to respond to them and what might make the most sense, and who else might be involved. I know this is an area where there's a lot of involvement by a variety of disability organizations, and I don't disagree with the scope of the problem you're describing. I just we'd need to give some collective thought to what we can do beyond the regulations, but certainly these draft regulations that are coming out are a place for us to look closely at some of the issues you've raised.
Well, I'll start with that, and then also with the two requests that the chairman made. And then the rest, I guess will just kind of bubble up, and there'll be conversations, and I'll be back again, and I don't expect, action in the next 3 months or even necessarily 6 months on the bigger issues of, holding hearings or having an advisory committee and so on. And I realize that that's also has to do with budget and staffing, but it's something that you can consider in your requests for budget and staffing in the next go-around.
And then,
go ahead.
Oh, just one final point. Obviously, the greater department is the enforcement agency. The council doesn't have authority on that, but and Director Kish will be here at the next meeting, hopefully, that you're able to attend. But he did relay to me that absolutely there is the ability, and the system is set up that way for organizations such as yours to file complaints and have them investigated and enforced, even if there's not an attorney-client relationship with the aggrieved party. So certainly, it sounds like you did that with respect to Sacramento.
Yeah, and I was told, bring us an individual, we're not going to let you do that. So it's like, okay.
But you can't, so if there was an individual that you witnessed with this problem, are there not individuals interested in, even if you're the ones kind of asserting it. Can you identify individuals?
No, I identified
Yeah.
all the case numbers that I found in my research. And remember, this is a 100% volunteer effort at this end.
Sure.
Okay, so.
This end too.
Yeah, I know.
$100 per diem.
Except you have staff, okay, and statutory authority, and purview to some extent. No, but, things are fluid. This is new. And I remember when I first approached the secretary and the director, just after you got the 11135 authority, after the department did, and he said, this is like, it went into effect 3 months ago, and now here you are. And I said, yeah, just by chance. But so I said, let's do something. He said, well, bring me a case. And I was thinking, how do I do that when the individuals don't even know this is happening to them? And there's a conflict of interest with the parents and relatives who are the ones that don't want them to have an attorney appointed. That's why they filed for a general rather than a limited, to avoid that and to make it more expeditious. So I thought, well, I guess the way I'll do it is just pattern and practice and show, in a 2-month period, here are the specific case numbers where no attorney was appointed, a conservatorship was ordered, and it's obvious to anybody that an individual with such disabilities, that it's actually an order is entered, how could they possibly effectively represent themselves pro per, unlike many criminal defendants that do it very, very well. So, who don't have such disabilities. So, so when I went to the court first, and when they said, bye-bye, then I went in the form of an inquiry, not really a formal complaint, but then they denied it, because I was asking the director to open up a director's investigation, and they said no. Then I filed an appeal. Then the appeal was denied, and that was the end of it. And I was told, come back with a specific individual who's willing to do this. And I thought, okay, but again, we're in the beginning stages of an area of law, just because in this one case, maybe there's been some evolution of thought within the department on this. And just because, I got slapped down once doesn't mean that I can't come back again and say, okay, let's try this again, and maybe, it would be handled differently. So I'm very open to that. I'm glad to hear that he wanted you to relay that information. So let's just work together and see where this proceeds, and I'll try to address all of your concerns, specific language on the regs, the 2 things that you requested, and knowing that this is an ongoing process that could take, some of things quicker than others, and others could take a long time. But I started this in 2012, and, here we are now. So it took 5 years for the Judicial Council just to adopt new training requirements, and the work just begins now, because new training requirements are nothing without performance standards and without this and that. So one thing leads to another, but it may involve, at some point, legislation and some other aspects of it to address the issues that you mentioned. I realize that. So let's just see where it goes, what comes up, what you feel is within your purview, what you feel would be a priority area for you to devote other resources to beyond the regulations, and what we can do with the department, and then just let it evolve. But the evolution, your receptivity today is encouraging to me. And because, believe me, most of the times it's avoidance, denial, and delay by every single official that we've gone to. So this is a refreshing change.
Well, thank you for...
I just want to also extend my thanks to both for all your work and your bringing it to us and your ongoing, commitment to it, and to reassure you that we will and are going to take this seriously, and, first looking at the regs, and encourage you to continue to participate.
I will. Okay. Thank you very much. I appreciate it.
Thank you. Any other public comment on 11135? All right, well, let's move along to the consideration of modifications to the employment regulations regarding religious creed and age
You don't want to do
discrimination.
hate violence first?
There was a quick update.
Sorry, you're right. Let's do that. Good catch. Before we get there, we will hear a subcommittee report from the subcommittee regarding hate violence. So I'll turn it over to Councilmember Ortiz.
I only have a little bit, so I'll go through it. You know, initially I was hopeful to have public hearings perhaps in the inland region in October. We had talked, and I'd reached out to the Study for Hate and Extremism at the California State University at San Bernardino, and Dr. Levin at that location. He's been doing presentations before the federal government on, you know, threats to the homeland, particularly white nationalism, and is unavailable. He was looking more in the time frame of perhaps February. So I think we need to reconvene our committee to talk about whether we want to wait for him and whether we want to coordinate on that, or whether we want to look at a closer date, perhaps without the buy-in from the Study for Hate and Extremism. I personally think it would be a good idea to pair with them on a presentation or on public hearings. But I'll turn it over if you have anything to add.
No, I spoke yesterday with the district attorney for Contra Costa County, and there's a lot of local work being done on hate violence in the criminal context, and I wondered whether, you know, we can, I know we're focusing on the Inland Empire, which is good, I think we should, but I wonder if there's also a way that we can do outreach to others around other parts of the state who are not going to make it to whenever we end up having it, that we can incorporate or maybe set aside a particular agenda item so that we can collect some people from other parts of the state to talk about what they're doing. Because in Contra Costa County, there is apparently a local, I mean, there is a groundswell of activity around hate violence. They've recently had an experience of a shooting that has caused a lot of grief. And so, you know, I'm just wondering if we can maybe as a council kind of talk about whether we want to incorporate or create an agenda item on our regular meeting agendas to have people be able to invite people to come to talk about hate violence.
Well, go ahead, Jim.
Yes, I think we talked about that last.
A little bit
and I
we
thought we
did.
agreed that it would be valuable to do. So I think I certainly would, so I would suggest, you know, certainly for the next meeting, wherever we're going to be whenever that is, I would encourage the committee and others to reach out to people and invite and have it on the agenda as an informational item to have people give testimony.
And especially, I think if we're going to do another Bay Area or Sacramento, I mean, I think the Inland Empire, that's close enough that we can hopefully draw in folks from LA County.
Agreed, and I don't want to make it a geographical issue. I mean, let's serve the issue, not the geographic region, although I do think there are certain regions of California that don't usually get their say, and I'd like to make sure that we incorporate them.
Absolutely.
That makes sense to me. I mean, just realistically, it's almost November. I don't think we're going to have a hearing between now and February, so it just seems with the holidays and everything that aiming for a February date makes a lot of sense, particularly since there's a really key speaker. So from my perspective, trying to develop a concept for something in February or, you know, whenever it makes sense to me. And I think it does make sense to try and tie that into some local testimony so that we have a designated time-limited spot on each of our agendas in a couple of regions over the next year to tie into the bigger hearing that you're doing in the Inland Empire, or that we hope to do in the Inland Empire, so that those things could all come together for some kind of report, perhaps.
Yeah, I agree on timing. I think February or March is probably realistically the earliest we can do this anyway, and certainly given the opportunity to pair with them, that makes a lot of sense. I'll say, both with respect to this subcommittee on hate violence and the council more generally, we are always open to having as an agenda item a guest speaker that's addressing a specific topic, and so I encourage people to reach out to people that they think would be good, and obviously just let the department know, or I know, and it'll get on the agenda. And that has proven inspiring or informative in the past. We had Professor Zatz and Maurice Enselem come and talk about criminal history and employment decisions, and that kind of launched our rulemaking there. So certainly always be on the lookout, both in the context of hate violence or elsewhere, for people that can come give a presentation to the council on an area that we should be examining.
Yeah. And I think it would help if we can get meeting dates ahead of time so that people can get on, you know, their schedules are going to be busy. So the sooner we can get a meeting, the next couple of meeting dates, instead of just maybe having if we could schedule 2 or 3 ahead of time,
Yeah.
so we have those dates, that would be helpful.
Yeah, I think that would be up to Brian to circulate a
If we could
poll.
try to get some hearing dates, I mean, our council meeting dates, a couple of them arranged in the future, that'll make it easier for us to pull in speakers.
Yeah,
And let me just say, I'm thinking, given what we know about the status of the 11135 regs, we'd probably have time to notice a 45-day comment period in advance of a January meeting.
It would be tight.
Tights.
Oh, you think it won't be till February?
January would be tight. But we could try. It depends upon how quickly the fiscal review takes place.
That's always the tricky part in terms of noticing multiple meetings in
Right.
advance, is we're playing off of other time lags that we're.
Well, let's check in and see if we can get a meeting late January. Otherwise, we could potentially combine a meeting in early February with the hearing. Otherwise, we might have a late January meeting and a hearing in late February. But I would like to get the 1135 regs teed up as soon as we can. So
Right.
I think Brian, after you consult with people internally, we have a little bit better sense of the timeline, you might just circulate some proposed dates.
Yeah, absolutely. So once we either have the fiscal sign off, or if enough time has passed and we can anticipate when we will get it, it'll be much easier to plan from there.
Okay, thank you.
Do you think that'll happen like in the next week?
No.
Or, no, that part won't happen in the next, okay.
Not the next month either.
Oh, not the next month? Okay.
5 weeks, 6 weeks, I think. It's
Okay. I shouldn't hold my breath. Okay.
Got it.
All right. Any public comment on the report from the subcommittee about hate violence?
Thank you for all this work.
Yeah.
Before we move to public
For
comment.
following up on that.
Any emailed comment, Brian?
No.
All right, so let's move on to consideration and of the modifications to the employment regs regarding religious creed and age discrimination, which is attachment E to the meeting materials, and I'll turn it over to council members Ortiz and Iglesias.
So I'll simply say, and thank you to Councilmember Iglesias for all the work we went through and incorporated comments from both SELA and the Chambers of Commerce. For the large part, most of SELA's comments were clarifications that were accepted. There were a couple items with regard to the chambers where we had a difference of opinion as far as clarification, and really only one item with regard to the law where the chamber was pushing toward a looser federal standard. We saw that the state standard was a little bit more onerous and kept with the language that we had originally indicated. I'm giving kind of broad statements. Is there anything you'd like to add?
No, I think that's good, thanks.
Well, I certainly, having read all of the comments, appreciate the subcommittee's in-depth treatment of them. Any council member comments before we turn over to public comment?
I had a couple. I think it's really good. But at page 3, I just wondered, you used the term business necessity several times, and in the other parts of the employment regs, we usually talk about job relatedness and business necessity. We use them together, that you have to prove both job related, the employer has to show both job relatedness and business necessity. And I'm wondering if it would make sense, and the 2 places that I really highlighted that on page 3, sub C3A, and then it appeared again in 11076A at page 5, where you talk about where a legitimate business necessity exists. I wonder if it would be, it would make sense to say where it's job related and a business necessity exists, even where it's the practice may still be, for example, I'm looking at 11076A. The practice may still be impermissible even if it's job related and a legitimate business necessity exists, or something along those lines.
Certainly, I don't have any issue with that. I think that adds clarity, although I would suggest that business necessity necessarily incorporates job-related.
Well, so this came up in the criminal history regs, and I think that's right. Someone pointed out the first draft of criminal history regs, and you'll see as we get to that, in the existing language, there's a quote behind job-related and consistent with business necessity, because I think as we define them in the general regs, they're a tandem thing. So I don't think in our regs, it's one definition that incorporates the entirety of the phrase job-related and consistent with business necessity. It's not two separate standards, but having, to pick up on what you're saying, Councilman Brodsky, I would go back and look at the early definitions in the general regs, because it might be a term of art to find in that respect.
Yeah, that's what I was thinking, because we use it, we should be consistent as we do it. And then the other question I had was a different one, but in that same 11076, establishing age discrimination A. You say a presumption of discrimination is established. It seems like that kind of, I'm not going to be able to articulate it well enough, but that sounds like almost like there's a burden of proof on it that is not, when there's a presumption, the presumption is, well, how I was thinking rewording it was, there's a presumption whenever a facially neutral practice has an adverse impact on applicants or employees. Because, and maybe this is just, maybe I'm off base on here, it's just something to think about, because I don't know, it established seemed to add another layer onto it, that there is a presumption if there is an adverse impact, right? And so that's, I understand that, so it's the adverse impact that establishes the presumption, but by using the established in there, it almost sounds like it's separate. I don't know.
So sort of, instead of being language, it sounds like it's directed to a complainant trying to prove it.
Correct, yes.
More of a factual assertion
Yes.
that a presumption is. Yeah.
Yes,
I see what you're saying, just in the way it's phrased.
yes.
So what was your?
I think the alternative, I said something like, there is a presumption of discrimination whenever a facially neutral practice has an adverse impact on applicants or employees age 40 and older, unless the practice is justified, blah, blah, blah.
Will you send us that language? I don't see any problem with it, to be honest.
Yeah,
I mean,
it'd be
look,
helpful, yeah.
I defer to your English ninja skills. For me, they seem, the phrasing seems equivalent, but I'm fine with your phrasing as
Okay.
well.
Yeah,
So
so
long,
if it's not incorporated today, I can send it to you, but for background reasons,
Of course.
Councilmember Brodsky
I can't.
You could watch the video, but basically it's getting at, instead of, right now it's written essentially on how to do it if you're a complainant, right? A presumption is established if you show that a facially neutral, and this, I think what she's getting is just like a declaratory of law, that a presumption of discrimination, there is a presumption of discrimination
passive voice.
where a facially neutral practice has an adverse impact.
Passive voice here implies that it requires other elements of proof.
Yeah. So I think I can read the exact change. It's,
Well, then maybe we want to make it, because depending on the public comment,
yeah,
we may not have another turn of this. so
right.
that
I
would
would
have
suggest it, and I think what I'm hearing is an insert, no, strike A at the beginning of the sentence. The sentence will start, there is a presumption of discrimination, and then we strike is established by showing that, and instead it reads, there is a presumption of discrimination whenever a facially neutral practice, et cetera.
Right.
Yeah.
Does everybody have that? And I think
And
that
then,
would be
yeah,
good to make.
that's what I, yeah. And then I don't know how you want to go back and look at whether to add in job-related and consistent with, that's the wording is, it's job-related and consistent with business necessity, is that phrase. that
Brian,
is
can you pull up
used.
the definition of that elsewhere in the regulation?
Let's just stay with the term as generally used throughout. And
Yeah.
my reading is business necessity necessarily incorporates job related.
Yeah,
but
it's
I'm
not two
fine.
different things.
Right.
Well, except that the phrasing is job-related and consistent with business necessity. That's the phrase.
Right.
My recollection from the,
Yeah.
from the other ways we've used it.
So unless the practice is job-related and consistent with business
Yes,
necessity.
yes.
Oh, and it's saying, it's cross-referencing, it's section, isn't 11010B?
That should,
Because it's being, we have it in that sentence.
you may have it in your housing, in the criminal one.
No, it doesn't cover that.
Oh, no.
Yeah, well, they're 11010B, right?
Yeah.
Okay, sure. Well, really, it's just about the phrase, like, is that defining business necessity or job-related and consistent with it?
Business necessity.
Oh, okay.
So business necessity, where an employer or other covered entity has a facially neutral practice that has an adverse impact, i.e. is discriminatory in effect, the employer or other covered entity must prove that there exists an overriding legitimate business purpose such that the practice is necessary to the safe and efficient operation of the business and the challenged practice effectively fulfills the business purpose it is supposed to serve. The practice may still be impermissible where it is shown that there exists an alternative practice that would accomplish the business purpose equally well with a lesser discriminatory impact.
Oh, so it is, okay, so it's
it's
just the
not.
definition of business necessity. And maybe job-related, that came from case
Job
law.
relatedness is the next provision. It's,
Oh, okay.
it's sub C, so
I think it's in the statute.
Well, and does it need to be job-related? I mean, if it's a business necessity, even if it weren't related to the job per se, although I'm trying to
But I
reach
think,
out
I
and
think
figure.
I think just adverse impact legal, like case law or maybe even the statute is that it's job-related and consistent with business necessity.
I think that's right. But regardless, it sounds to me like the statute is business necessity, so we're fine with the term
Well, that
as
was the
is.
regulatory definition.
Right.
Well, why don't we leave that for now since this may not be an on the fly.
Well, I think it
Or maybe we should change it. I mean, we can always change it
Yeah.
again in public comment, but
yeah,
because I think just adverse impact law, it's job-related and
it
consistent with
is.
business necessity.
Yeah.
I'm going through the statute right now, and I can tell you.
There's
It comes up 5 times. Bear with me just 1 second. So job-related and consistent with business necessity, job-related and consistent.
If that's the phrasing, perhaps we should go back in the definitions and correct it there as well. I mean, if it's in the
Well,
regulation.
it's two different definitions.
It's two
We have
different
job-related, and then
definitions.
D is C.
Because the phrase, and we use the phrase, I think, in other parts of the regs as well as,
So really, like here it would be 11010B and C, and then we would change it to unless the practice is job-related and consistent with business necessity.
right. So it was at page 3,
And
A,
5.
And
and
five.
page 5. I think it appears twice in that paragraph. A, 11076A,
Even where a legitimate business necessity exists, right, below.
yeah.
Even where it's job-related.
Unless the practice is justified by business necessity as defined in 1101, 110110.
Right. So
Yeah, the statute itself is inconsistent. There are places in the statute that just refer to business necessity. But I do believe that as used in practice, business necessity is necessarily job-related. I think for clarification, I agree with my council member here that we should use the consistent term job-related and consistent with business necessity. So 3.5, I would suggest we make those changes. In addition, changing to the passive voice, as Councilmember Scher had suggested, I think that would be.
So I think as
I
we
would agree.
I think as we voted into the next draft, it will be with those changes incorporated for purposes
Okay,
of the next
good.
comment period. Any other comment?
I have a comment, another comment on another topic, although it's actually not a comment on a change you've made, so I don't know that we can address it now, but I wanted to raise it because it kind of overlaps with some of these changes. Just looking at A1, I was struck all of a sudden. 11016A1, duty not to discriminate. It says, nothing in these regulations shall preclude affirmative efforts to utilize recruitment practices to attract minorities. For one thing, that's a little bit of a troubling term. I think we mean people of protected classes. And then it says individuals of any sex, and that struck me as odd that you could heavily recruit white men, for example, in an industry that's always heavily men. I think the intent that you could recruit any underrepresented sex, would make sense to me. But
That sounds really antiquated.
it just,
Yeah.
both those terms
Yeah,
just
no.
struck me as kind of troubling.
Yeah.
And I don't know if we'd ever looked at them and if there was other language they were tracking, or if that's something we want to fix later, or if it can be tied into this change. It's
What if we
not
just
really
struck all that? I mean, because it ends
Yeah.
with, and any other individual protected by the act. So why not affirmative efforts to utilize recruitment practices to attract individuals protected care?
Our purpose is to provide greater clarity and not less. I think by striking everything, it becomes more vague. I mean, that's just my thought off the cuff.
Right.
It wasn't something that we looked at going forward.
I know, and that's why I'm saying it may be for different rulemaking, but
Mm-hmm.
I am certainly troubled by both those phrases, because I think they're both antiquated, but also kind of not fully
Now it's
inclusive.
wrong. I mean, you can't really try to, well,
I would, we
underrepresented.
should look at this
Right.
and change it. One question for Mr. Sperber, would making such a change be within the realm of what we noticed with regard to what this particular regulatory action is about?
It would have to be something that the public can anticipate, but because this section is covered, I strongly suspect OAL would be okay with it.
Thank you.
Couldn't we cleanly just say to attract underrepresented members of any protected category?
Well, I think we should bracket this and look at this further, because I'm not even sure how true this is
I know.
at this point. I mean, certainly the state constitution prohibits it, I think, for,
Affirmative action.
right.
Prop 209.
Right.
But I'm sorry to interrupt, but police departments quite frequently are underrepresented when it comes to minority candidates.
Right.
And they should and do look toward recruitments so that they're more adequately representing the communities they serve.
Because that's like a business, probably a BFOQ.
Absolutely.
But, I
Right.
don't think there's anything that, I think there's a big difference between affirmative efforts to utilize recruitment practices and preferences for people in hiring. So I don't think this is barred by the constitutional provision, but I agree exactly how we frame it
Yeah.
is tricky. So I don't know. I mean, I'm happy to try and mess with it now, or I'm happy to table it, but I do think it ought to get looked at and changed.
Would it be, I mean, along the lines of what you were suggesting, Chai, to say, however, nothing in this regulation shall preclude affirmative efforts to utilize recruitment practices to attract individuals protected by the Act?
Well, all people are protected. So for instance, males are
Right,
protected by the
yeah.
Act. And if it's a group and we just
Yeah,
want to,
so it would have to, but then how do you,
Underrepresented.
underrepresented individuals protected by the Act?
I'm happy with that, but, I also value the opinion of this group.
I mean, so I think we'd still have to look at underrepresented, like what does that mean in a
What does that
particular
mean?
job? Like underrepresented in the community, underrepresented in the police force, but I think it's better than this. So to the extent we're going to re-examine another rulemaking, I'd be inclined to add that instead of this for this rulemaking.
I agree. And we may end up changing it, later revising it again, but I think it would be.
Well, do we want to reference a bona fide occupational qualification? In other words, underrepresented as applied. So for instance, or is that getting too deep into the weeds?
Well, let me just speak from the disability perspective, which is we want to encourage people to seek out and hire people with disabilities who are an underrepresented group just about everywhere, but having a disability is not a
necessarily a
BFOQ. So, I certainly, I don't have any problem with affirmative efforts to attract individuals with disabilities.
Isn't it always a BFOQ though to adequately represent society at large or community? I mean, maybe not.
No.
I feel like there's too much like legal research that we need to do before we like substantively revise it, other than I think we should, for now, change it to be
Yeah, so however, nothing in these regulations shall preclude affirmative efforts to utilize recruitment practices to attract individuals, I'm sorry, any underrepresented individuals who are protected by the act.
That seems like a better placeholder than the current line.
I think that's helpful. And
Yeah.
thank you for pointing that out, Councilor Ventura.
Underrepresented individuals.
Yeah.
Who are-
And maybe the underrepresented should modify the class.
Members of a
not-
protected
yeah.
category.
All right.
Yes, it should. You're right. Individuals,
Who are members of underrepresented protected classes.
Yeah, I think that's the best phrasing.
yeah.
One more time, please.
So, nothing in these shall preclude affirmative efforts to utilize recruitment practices to attract individuals who are members of, any individual who is a member of an underrepresented protected class.
Protected class covered by the act or just protected class?
I think protected classes, well, doesn't matter, covered by the act.
Protected class covered by the act.
Or under
Yeah.
the act.
Okay, and then we may need to tweak it further,
Yeah,
but I feel like it's better than
Yeah.
minorities and
definitely.
anybody.
Now, the
Anyone
rest
on
of
the
the-
basis of sex.
Anyone.
The rest of the sentence, not to be a
Recruit
stickler
anyone.
here, but the rest of that paragraph talks about individuals on basis enumerated in the act. So underrepresented basis enumerated in the act, just
Oh,
to be
yeah,
consistent
right.
with the rest
Yeah,
of that
yeah.
paragraph.
Yeah, yeah, yeah.
Any individual who is a member of a
It seems like an archaic phrasing to me anyway.
group on any individual who's a member of a group enumerated, protected in the act. I think the language we have is okay.
I don't care, it's fine, because we may end up changing it anyway. I'll just keep it protected class.
Any other council member comments? Any public comment?
I just want to say I liked your examples. I liked the modern, like bringing it up to date about digital, I mean, all of that, that was really helpful to me.
Well, I mean, I think our purpose is always to give clarification to the employers out there, and I don't want it to be a guessing game, and I don't want it to be a trap for the unwary. So I'm glad that we kept the examples that we put forward.
Yeah, they were really, I think that was really helpful. Digital natives, I never heard of that term.
Oh, yeah.
I'm not one.
None of us are.
Any public comment on attachment E? Any emailed comment?
Nice job.
But if I could just ask one more time for the final wording of 11 and 16.
Recruitment practices to attract any individual who is a member of an underrepresented protected class covered by the act.
So, seeing no public comment, I'll solicit a motion to adopt attachment E with the modifications that we made at the meeting today, and to have the text of the regulations approved by the council and then posted for an additional 15-day comment.
So move.
Second.
All those in favor say aye.
Aye.
Aye. Any nays? Any abstention? All right, motion passes. So we're at 11:40. I think we could kind of power through here. We've got a couple more agenda items, and I don't think they'll be super long, so why don't we try to tackle them
good to me.
before the break. So our next order of business is consideration of employment regulations regarding harassment prevention training, and that's attachment F to the meeting materials. So this is one I've been tackling. As a reminder, the legislature passed SB 1343, and that expanded the harassment prevention training, which was formerly limited to larger employers and supervisors, to be applied to, employers with 5 or more employees, basically every FEHC covered employer, and the training has to be to all employees, not just supervisors. So after that passed, the department was contacted with a lot of questions about how it applied in various contexts that aren't explicitly addressed by the legislation. We then had SB 778, which delayed the deadline for that training, so that the new deadline is January 1st, 2021, not 2020. So that gives us time to provide regulations that will coincide with the implementation of this expanded prevention requirement. So the regulations that you see in attachment F are drafted in a fashion to be consistent with the law as it will look at that juncture. In other words, when we talk about training requirements for employees, that's not currently, the deadline has not come for that, it's just supervisors. But by the time these regulations are intended to be in effect, that will be. So they're forward-looking in that sense. In addition to the kind of intuitive modifications of implementing SB 1343, I want to call your attention to a few that are addressed mostly on page 8 that answer some of the questions from the public and implement this in various contexts. The first being 11024B8, which is in the middle of page 8, and that's training of employees that are minors. So that gets at, all right, well, how do you provide sexual harassment prevention training and other harassment prevention training to employees that are minors? And the language here borrows from the legislature's recent language in Labor Code Section 1700.52, which addresses sexual harassment prevention training to minors in the entertainment industry.
Did they pick the starting age of 14?
Yes.
Wow.
So that's in that statute, so it makes sense, certainly.
Oh, it's in the statute.
Yeah, so the legislature recently passed a statute
Let's give 14
that
as
talks
the age.
about this. So,
I actually think it's late, but anyway.
I do too, but
but how could we argue?
no,
with
I
the
know.
You
other?
can't argue with the statute.
I get it.
I mean,
now.
I just think kids
Right.
young girls much earlier than that face these issues. So.
Right. Well, and you'd think especially in the entertainment industry, but I mean, that's a very recent legislative directive, and it provides consistent, in addition to it being indicative of where the legislature is, as a practical matter, it provides a cohesive compliance, ability. And then 11024B9 and B10, which implement, our new law, SB 1343, 12950.1's requirements in the context of seasonal and temporary workers and migrant and seasonal agricultural workers. And then on page 9 at 11024B10, that's implementing a separate law, SB 530, which addresses the requirements and logistics of training unionized workers where they're in a multi-employer collective bargaining agreement in the construction industry in terms of when they get trained and who keeps those records and how that's done. So that's kind of an overview of what's embodied in these regulations.
Can I just ask one further clarifying question about that age 14?
Yeah.
Would it be inconsistent with the statute if we allowed employers the option to provide training to younger workers with the consent of their parent or guardian, but didn't require it?
So I think we looked at it, and I don't think. Let's go back to that statute because we talked about this, and I don't think anything prevents an employer and a parent and a minor from getting trained. So it's just about what's required of the employer.
Right, but I'm just wondering if we could make it explicit to sort of might provide some encouragement to employers in some industry to provide
Right.
some training.
Right now, it says employers are not required to provide the training mandated to minors younger than 14. So that's in the middle. That's
So just clarifying, they're of course free.
are not required, but
To-
are permitted to.
So I'd say this is not going to be, well, I'd say let's get the public comment and look at that, but we can look at it, or we can look at it right now. It's Labor Code Section 1700.52. We can bring that up and see. Although I think that'd be better to look at for public comment because I think it implicates a lot of things in terms of how we phrase it with parental consent
I do
and
too.
things like that. So I think it'd be a good thing to add, but let's let's look at
To-
kind of the various.
Add now and then
No,
get
to add
public comment?
after we get public comment, and we have time to look at
Okay.
kind of other pieces implicated, about how they would do that.
I'm certainly in favor of that because that one's also struck me
Yeah.
as well. One question I would have would be on the regulatory side, Mr. Sperber. Would OAL object to us saying something is
Right, that's the
encouraged,
other problem.
but if we're not actually implementing a statute and making a requirement?
We've had inconsistent feedback. That's typically the kind of thing that we could do a line item strike at the very end if there is an objection. So I wouldn't let that get in the way.
And
Right,
it seems
especially
to be-
since what we're doing is clarifying that it's not prohibited.
That's right. As
We're not
long as we're saying it's
encouraging.
permitted, you don't have to, but it's permissible.
But
Is this a slippery slope? Like, for instance, I think 1 hour is a very limited time to go through everything that we're going, and I've been recommending to many clients that they do 2 hours even for the hourlies. I mean, do we want to go down what's the best thing you could do? Are we going to add more than that? I mean, we're talking in the context of younger than 14, but should we add what else we could do that might be better?
Well,
I guess I just have concerns of how far we want to go with that.
I think the reason I'm suggesting it here is because it's so specific, it might be interpreted as prohibiting, even though it doesn't say that. And I want to make sure people don't draw that inference.
So I think we should examine that for clarity, but I think if we're gonna implement it, then we have to say, nothing saying you can't do it, but then that begs the question, all right, well, you can't just foist it on someone. I mean, the 14 is with the parent there, so I think if
It
we're
didn't
gonna.
have to be with parental.
Right, but
consent.
I think that, whatever that having to obtain parental consent begs some questions that would be better thought out and researched than on the fly edited.
Okay, but to respond to Joe's particular question, I think we say a minimum of 1 hour, don't we?
We do.
So that leaves open already the option of multiple hours, and we don't say anything equivalent here. That's my only, that's why I'm drawing a distinction.
So if that's not it is underlined here, so we can change that part. Okay, never mind. Yeah.
But I'll just add the statute silent on it. Not to say
Yeah,
could or
right.
should, but I'll just tell you.
And there may be regs, and we can think out what parental consent and all that. But in any event, there will be public comment. I mean, this is the very beginning of this process.
Yeah.
I had a
yeah,
couple
yeah.
questions about it. Are you done?
I am.
Okay. So I wondered about the duplicate training. So when an employee leaves and goes to another employer, you've got that really well set out, the procedure. But I wondered, the last thing it said, the burden of establishing the prior training was legally compliant with the section shall be on the current employer. But it seems to me that if the employer has that burden, which I think it should, the employee should at least be required to provide the certification that's required by B2 to the new employer.
So this is existing language.
I know, so that's fine, 2 is fine, but I just wondered, so an employee who's received it, and wouldn't it be helpful for us to say that the employee should provide?
No, I mean, I think this is saying, look, if you're a new employer, you don't have to train someone if they've just been trained, but like, either take the risk that they weren't trained right, or train them. Like, if you're not going to train them, you're shouldering the risk that training was compliant.
I don't know, I'm sympathetic. I know a lot of employers will just take their word for it. You got trained, great. I think it would be good to be able to say there's some kind of authentication. Maybe not the certificate, because I think, frankly, people take their training and put it right in the circular file when they get it.
Right.
But some kind of record to show that they did it and who did it, as opposed to someone just saying, I think I already did that, don't worry about it. I think that there are some, especially smaller
But is
employers.
that a regulatory change, or is that if I'm an employer and I'm deciding whether I'm going to train this person or not, and they're saying, oh, I was already trained, I say, okay, well, bring your certificate to me. Like, burden's on me to show it, so if you bring your certificate, you don't have to come to my training. If you do, you better be there. It seems like an employer can just do that.
I guess that's true.
That makes sense, yeah.
But then if the employer could just do that, couldn't we provide some guidance saying that they can do that?
But what would I'm not against it, I'm just trying to figure
I
out
was
what it
just
would
trying-
look like. Are we saying employee, it's your obligation to a new employee? I mean, what would be the mandate there?
But if they're
I
going to.
guess it's really up to the employee. I'm kind of thinking back, okay, if he or she doesn't want to do the training, then they're going to have to provide some documentation. Otherwise, the employer can say, well, then you've got to do it.
Well, and that we should advise the employer that it's at their risk, that they would take, some kind of verification from the employee that the AB 1825 training has been provided. And maybe we'll leave it on them, whether it's a certificate or a
Well, that's what
roster
we
of
have,
attendance.
right?
Right, that's what it is now. Although the employer keeps the certification, and sometimes maybe an employee's not going to ask for it or not going to get it. And then they go to a new employer and maybe they didn't want I take it back. I think it's,
Well, let's think about
Okay.
this. I mean,
Okay.
those, again, we'll have an opportunity to change it.
All
but
right.
In terms of on the fly.
and then I just had a couple little language things. In 8 and in 10, the word fashion, in the same fashion, shall be trained in the same fashion. I just like trained in the same manner. I mean, fashion seems like a weird word to use in a regulation. So that's the second line of 8 and in the third line of 10.
Yeah.
And then just a question. So you use the word in 9 and 11, what they can do. And I'm used to thinking of, should that word be may? Employers who hire seasonal or temporary employees through union hiring halls can contract with the union? Or is it may?
That might be
And
statutory. Can you look
Is
up
that, and is it intentional? It might be intentional, they have
950.1,
slightly different
yeah.
meanings. But usually may is more,
Right. Yeah, I hear what you're saying. But for some reason, I think that might be directly statutory.
I mean, can means you have the ability to do it. It doesn't mean that you're permitted to do it.
Like you're physically capable
that's
of doing
right.
it.
That's
But
right.
that might be the way it's phrased.
I know, but I mean, if they-
If it's not, then
if-
I'm all for it.
And even if it is, and what it intends to say is you may, I mean, that it's permissible to do that, I think it probably is clearer to use the word may.
I'll just read it out. Beginning January 1st, 2020, this is old, the time has since been updated. For seasonal and temporary employees, or any employee that is hired to work for less than 6 months, an employer shall provide training within 30 calendar days after the hire date, or within 100 hours worked, whichever occurs first. In the case of a temporary employee employed by a temporary services employer, as defined in Section 201.3 of the Labor Code, to perform services for clients, the training shall be provided by the temporary services employer, not the client.
No, but it's really this other stuff.
This is different from that. This is employers who hire, here, just use this example, employers who hire seasonal or temporary employees.
Oh, okay, so this is,
Union
yeah,
halls.
right. So let's change that to may. Okay, I
Okay.
remember. This is
Okay.
getting at a question of, that was kind of from members of the public about, well, how do we do it in this context?
So that would be in
So,
9 and
nine.
again in 11.
What are we
Okay.
changing? I'm sorry.
Can to may.
Just nitpicking, sorry, but this was a lot of work. I mean,
Yeah.
this was
Good.
obviously
nice
a lot of
job,
really good work.
especially since it was just you.
Subcommittee of one? Well, it might be
Yeah.
a good one for Councilmember Sandoval to join when he is at our next meeting.
That's all.
Any other council comments? Any public comment? Any emailed public comment? All right. So with those modifications incorporated in terms of changing fashions to manners and cans to may in the sections identified, I would move to have the new proposed employment regulations regarding harassment prevention training contained in attachment F adopted and authorize the department to prepare a rulemaking package and notice the regulations for public comment.
Second.
All those in favor say aye.
Aye.
Any nays? Any abstentions? All right, motion passes unanimously. So we're at our last substantive agenda item, and that is the changes without regulatory effect to the fair housing regulations, which is attachment G, and I'll turn it over to the subcommittee on housing.
So, as Councilmember Scher had mentioned before, the OL signed off on the proposed housing regulations. Subsequently, we received communication from members of HUD that there was a minor, basically a linguistic problem with some of the phrasing in the regulations with regard to reasonable accommodation. Specifically that the phrasing, which occurs a number of times in the regulation, that basically describes an undue financial and administrative burden, which is the proper language, we had accidentally put in as undue financial or administrative burden. So this is clearly the law under and has been for a long, long time, and this is a minor, basically a sort of Scrivener's error. And so we are asking the council to ask the OAL to allow a change without regulatory effect, because there is no, we're not changing the law here. The law is as it is. We're just conforming our language to what the law is, and we have no real choice. We're asking the council to approve a request to OAL to allow there to be this change without regulatory effect. And alternatively, if OAL, for whatever reason, disagrees with that, that we would put in a new package to, regulatory package to make just this effect, this change.
All right, so let me just supplement that. The language is quite clear on the federal side, and we have to be consistent and provide
Is
benefits.
it the Fair
no
Housing
less.
Act or the HUD guidance?
It's in the HUD guidance.
It's in the HUD guidance, but it's been there for a long time. And so we have to be consistent, and HUD has called us out as being inconsistent, and that both provides less protection, which is a violation of FEHA, and it also potentially jeopardizes our funding, is not substantially in compliance. So this really is a change that we need to make. And so I think the motion is to authorize, as Tim said, staff to submit this change to OAL as a change without regulatory effect, and if that's rejected, to prepare and initiate a rulemaking package to move forward with this change through the regular rulemaking process. We think it ought to go through administratively, but if not, we'll bring it back and go through the process. Is that motion?
I would make that motion.
I want to make sure it's
Yeah,
clear.
I've got the official Brian approved language.
Go
Magic
for
words
the
that I'll read
magic words.
momentarily.
Okay,
But
I
before we
like
get-
magic words.
Before we get there, any public comment regarding this change without regulatory effect? All right, seeing none. So the motion would be to authorize the department to submit attachment G along with any necessary rulemaking documents to the Office of Administrative Law as a change without regulatory effect. And if the OAL does not approve this as a change without regulatory effect, to authorize the department to prepare a rulemaking package and notice regulations for public comment.
So moved.
Second.
All those in favor say aye.
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 Any nays? Any abstentions? All right, motion passes unanimously. Any remaining public comment that people would like to make on a topic of their choice that isn't tethered to an agenda item? All right, well, that wraps up today's agenda. Details of the council's next meeting will be posted in the coming weeks on the webpage. And with that, our meeting is adjourned, so thanks for participating.
That was a quick turn.